I'm going to take a minute to introduce everybody. As I said, this is really a pinch me moment. I'm really excited about this. So I'm going to start. We have Chief Justice David Nahmias here with us. And he is the Chief Justice of the Supreme Court for just a little bit longer. And forgive me, I don't know the exact date that you're rolling off, Chief Justice. Could you tell us that?
July 17. Not that
July. I bet that's probably just not a moment too soon for you.
It's good to know where the finish line is. But
I bet. And thankfully, we have Presiding Justice Boggs, who will be filling your shoes. Presiding Justice Michael P. Boggs is going to be taking over as the Chief Justice, and thank you for being here. So I assume that July 18th is your first day as the new Chief of the Supreme Court, and I'm sure you're anxiously awaiting taking over that role, but sort of with trepidation, I'm sure.
Yeah, I think anxious might be an overstatement, but yeah, that is the date. Thank you, Brooke.
And we also have Justice Nels Peterson here with us. Justice Sarah Hawkins Warren, excuse me, Justice Charles Bethel, Justice Carla Wong McMillian, and Justice Verda M. Colvin. And I know you all join me in welcoming all of them and thanking them for being here with us. And unfortunately, the other two justices could not be here with us today. They had scheduling conflicts, and we have had this on the books since January, and the justices have been kind enough to have this scheduled and share and hold this date for us. So we just appreciate them so much for doing that. And as I mentioned, put any questions you have into the chat and into the Q&A, and I will be checking those to ask them as we go through the panel. And this panel is for y'all, so any questions you have, please ask them. I want to start off by just asking a question. Justice Nahmias, what are you going to be doing on July 18th?
unpacking. I'm moving that weekend to a new house after getting remarried on July 2nd. So got a lot going on, and then I'm gonna start trying to go see my son play football at Duke, and school starts for my younger son about 2 weeks after that. So what I will not be doing is reading lots of draft opinions like my colleagues, but looking forward to it. And I'll do that, kind of take the remainder of the year off, and then I'm going to be teaching a class at Emory Law School, and I'll practice law in some capacity, but I haven't figured that part out yet.
Thank you. Speaking of Duke, I read up about everybody to prepare for this, and I was really surprised how many of you have associations with Duke. I'm not sure if people on the webinar know this, but more than half of you have some sort of affiliation. Justice Warren, you went to Duke for undergrad and for law school, and most of you have some sort of affiliation with Duke. I don't know if we have some sort of alumni association there or what, but y'all have a very strong tie with Duke. That just was interesting to me in reading about it, that this particular group has such a strong affiliation with Duke. I thought that was interesting. Justice Warren, how did you feel about Coach K retiring? Are you a basketball follower?
It's hard to go to Duke and not be a big basketball fan, but it was a great season. It was a tough one, tough way to go, but it does nothing to change the legacy Coach K left for our team and for our school. It is fun to have some camaraderie among schools on the court. Obviously we have great schools here in Georgia, but we do have 3 justices who went either to Duke Law or to Duke undergrad or both. We actually have a lot of folks in the clerk's office and other staff attorneys as well who've gone to Duke. So we've got a really nice contingent. And now we have a really good extra reason to pull for Duke football because the Chief's son will be playing football there in the fall. So it keeps things very interesting during sports seasons, which basically means all year round.
That's right. And speaking of sports, I asked y'all to send me a little tidbit about yourself that I might be able to share with the group. And many of you were kind enough to respond. And I wanted to share what Justice Bethel shared with me, is that he is very interested in local sports. He's still involved in the Dalton sports community, and he just hosted the soccer team up there over his house for dinner, the entire high school soccer team. Is that right, Justice Bethel?
Well, yes, the Dalton High School Catamounts have a quarterfinal match tonight. So usually they rotate through various, families and restaurants in the playoffs. And so my wife Lindsay and I were delighted to host them and feed them what we hope is a successful meal. But we have not just Dalton's team; we have a lot of great soccer teams up in our part of the state, and so it's a fun time of the year to be cheering on a lot of young men and women who put a lot of time, as you know, into what they do, and it's fun to watch.
I think that's important for us to remember as lawyers when we see y'all, whether we're seeing you in person or virtually. Sometimes we forget that behind the robe, y'all are people too, and you have families and lives and loved ones and things that you do outside of the court as well. And so that's important for us to remember. And I think sometimes for y'all as justices to remember about us as well. And so that's why it was something that I'm going to mention throughout our conversation here today. And I appreciate you being willing to share that with us. Because I think it's important for us to get to know y'all as people as well, in addition to academics and justices. I noticed that we have a question in the chat, so I'll go ahead and post that to Chief Justice Nahmias. If you could answer to us, what is your favorite or most memorable case during your tenure on the court?
That's a tough one. We have so many cases. I don't know how much the folks on the webinar realize, but we decide about 350 cases, or a little down during COVID, but normally about 350 cases a year by opinion. So that's about 13,000 cases over, more than that, over my tenure, and it's a little hard to keep track of everything. They're probably the case that I remember most, but maybe because I was disappointed, was we had a case about state charter schools that I wrote a very long dissent in, and it's never good to remember a case you wrote a dissent in because it means your side didn't prevail. But ultimately the state constitution was amended, so the view I had prevailed, which is a nice feeling that the people agreed with me, even if my colleagues didn't on that one. But that was a long time ago. And, I think the other point to make, and people may not realize this, but we try to treat every case with the same amount of seriousness. And, it may not be a big case to the public or the world or the state, but for the parties in the case, it's the only case they usually really care a whole lot about. And so, I'd never like to kind of pick out a case and say, oh, that was a particularly important case.
Well, and that's a good point, is that these cases are so important to the litigants. And although it may be one of 10 or 20 or 30 on your docket for that particular time, that's the one case for that particular person. And for us as lawyers, I think sometimes we forget that. And it's important. That's a great reminder for us as lawyers to remember that as we're going through our day. A lot of folks have not been through a car accident before, or divorce before, or this type of action before. And we need to slow down and perhaps give a little bit more information, or give a better explanation, or take a little bit more time to help someone through that. And I think your point is a good one, Your Honor, because that helps us explain it to them so they feel comfortable with the process as well, and understand what's happening. And that y'all take the time to really look at each case is what's most important here, so that each case gets the time it needs to be decided. And that's that's why you are where you are, so that you can do that for us. I wanted to bring up something that Justice Colvin did. It's not something that I could ever do, but it's something that she did with her son. Can you tell me, can you tell us, Justice Colvin, the tidbit that you shared with me that you wanted to or were willing to share with the group?
I told Brooke that I did Field Month with my son, who's an Eagle Scout. The first mother in Middle Georgia to ever go on the Field Month journey, which is treacherous, 96 miles over a 10-day course, switchbacks, and 1 shower in 10 days, and sleeping in a tent with a teenage son. So you can imagine, but it was memorable. I will never forget it.
And y'all were in New Mexico.
That's correct.
In
That's
July.
Yes. Very much.
So those are some added layers of difficulty in addition to the teenage son and hiking 96 miles. That adds to your bravery and difficulty for sure.
Climbing a mountain I never thought I would, Baldy Mountain. That's a feat.
And so we have a question about oral argument. When arguing for the appellee, do you recommend taking cues from the questions asked during the appellant's argument and addressing those issues first before turning to the appellee's main arguments? And Justice McMillian, could you answer that question for us?
Sure, I'd be glad to. I mean, I think you should approach oral argument as a conversation in which the justices, we have questions about your case, and to the extent you can answer those questions and gear your argument towards what we're interested in and what we have concerns about, that will help with your argument. So I definitely would recommend that as an appellee to listen carefully to the appellant's argument and the kinds of questions that we ask, and try to address those in your argument before you turn to other points that we may or may not have as much interest in.
I do think a mistake would be if you've just listened and you've identified exactly what Justice McMillian said. You know, there are these points of interest and things that we're exhibiting that we think are important. It would be a mistake to stand up and then read or recite a rote recitation of exactly what you thought you were going to say 3 days ago when you made that introduction. And there are all kinds of ways to maneuver around that. You know, you could come stand up and just say, you know, I heard you asking about this. I'm going to give you a brief answer to that before I tell you why my client should win for these 3 reasons. Or you could start, you know, a modified version of what you have, but quickly weave in the answers to those questions. But the main thing to do is exactly what Justice McMillian said, which is be flexible and show that you are listening, because this is your opportunity to answer the questions we might need the answers to come to the right answer under the law, which may or may not be the answer your client wants. But because it's that kind of conversation, you should feel like you can be flexible in the way you present that.
The one exception I might offer to that is if the questions we were asking of the appellant were about sort of the hardest things for their case. If you start sort of talking about the hardest things for your opponent's case, we may not take too long before we bring you back to sort of the hardest things about your case. But it is always good to adjust to where the conversation goes.
In terms of oral arguments, does the court have a policy or procedure, perhaps, where if a younger lawyer or a lawyer who has not argued in front of the Supreme Court before, if that person is going to present the argument, are you more likely to grant oral argument if that person is the one presenting it? Justice Bethel, can you answer that for me?
I'll give it a shot. We do not have a formal policy in that respect. I think you will find that in practice, that those requests for oral argument probably have a higher rate of success, because certainly we appreciate that the opportunity to present argument in our court is a developmental moment for attorneys particularly attorneys who are looking to practice in the area of appellate advocacy. I wouldn't say that it is not a controlling factor, but it is certainly influential.
Well, and unlike other courts, we do have sort of a general policy of granting all oral argument requests that are filed timely and consistent with our rules.
Thank you. And talking about oral arguments, Justice Warren, there's a question about your experience arguing in front of the United States Supreme Court and how that has shaped your role in the Georgia Supreme Court. Could you talk about that a little bit, please?
Sure, Brooke. That was an amazing opportunity, and I'll do what all judges hate, which is I'll answer that in a second, which actually you should not do an oral argument. But the thing that prepared me the most for the role I'm currently in is arguing in front of this court, is arguing in front of some of the people who are sitting right here, which was so incredibly instructive because it just simply is not a joke. I mean, it is an exercise that requires a tremendous amount of preparation. Anytime you're bringing a case, I mean, really in front of any court, of course, you have to be prepared, but any court of last resort, a court that has the authority to overturn precedent and is charged with defining law, in the last instance, like in our case with the Georgia laws and the Georgia Constitution. I mean, that is a very weighty exercise. And I had the chance to do that a number of times. Justice Peterson also argued before this court when he was the Solicitor General, and there are probably others who've done it in prior careers before they got to the bench. But that exercise for me was the first one that really opened my eyes to just how challenging, but also gratifying and rewarding appellate practice can be. That then helped prepare me for the U.S. Supreme Court, which is also a very challenging exercise. And of course, there's all the sort of normal intimidation that you face when you're going in front of the justices of the U.S. Supreme Court. But it really was excellent preparation to have already been in front of 9 justices at one time, which is a very different endeavor than arguing in front of 1 judge in a trial court or even 3 judges in an appellate panel. And so by the time I got to the U.S. Supreme Court, of course, I'd spent months preparing and had a lot of people who were helping me, and the team at the Attorney General's office all contributed to that. And I did just innumerable moots and practices and spent time thinking about it. At that point, though, by the time you walk in the door, all the hard work is already done. At that point, you're having that conversation. You have to trust that you've put all the work and preparation in. But for me, even though that was kind of the honor of a lifetime as far as an advocacy, from an advocacy perspective, what really helped on the preparation was the repeat times that I had to stand in front of Justice Nahmias and hear questions from him. So I also have a level of empathy, I think, that many other justices don't directly have, because I know what it feels like to stand at the podium and to be gripping on the sides of it with your legs shaking just a little bit until you get into that groove.
You've been in those shoes, literally gripping that podium, that same podium, recently. And let me ask a procedural question, and forgive me, because I have not had the opportunity to be in front of you during COVID, but if you're hearing an oral argument, are you all there in person, or are y'all there hybrid? How is that working for you? Justice Nahmias, could you answer that for us?
AJ, you want to go ahead?
Yeah, I was just going to say that, Brooke, we're all in person now. There was a very large period of time from the onset of COVID till a couple of months ago that we were handling oral arguments remotely. Generally, the chief would be in the courtroom. The rest of us would be in various places, whether it be at our homes, if we trusted our internet service, or we would be in the building. I was generally in the building because I live in rural Georgia and really not confident that the system will work that well for me. And so, but now we're all back in person. And so, we're back up to full speed. Several cases a couple of weeks ago, oral arguments coming up in a few weeks. And so everybody is in person. And we had even recently removed mask guidelines requiring folks to wear masks while they were at the council tables. And so from my perspective, we're generally pretty well back to our ordinary practices of oral arguments. And so, and I'll be honest, I think we all have different experiences with the remote practice. I didn't find a diminished level of argument among the practitioners that were arguing remotely. A little more relaxed, some of them, I think, than they would have been if they had been in the courtroom. Occasionally not wearing a coat, occasionally not standing while they were arguing. I did find, at least personally, that some lawyers tended to read significantly more with remote oral arguments than they would have ever read had they been in the courtroom. It's just awkward. It was easier for them to do that without, standing at a podium. But I thought oral arguments remotely actually were a pretty good success, and a lot of remote practices across the state, I think, have learned some pretty valuable lessons. But our oral arguments now are back in person, and I think we all enjoy that. We all enjoy each other's company, but we TD, that is, we bank every case after oral argument, and that's easier to do in person, I think, as well.
Excellent. Thank you for sharing that. Our next questions are sort of, I think, go in tandem. And I'd like to hear from each of you, if you wouldn't mind sharing. When is it that you knew in your law career that you wanted to be a justice? And perhaps we can start with you, Justice Nahmias, since you're perhaps leaving being a justice. Could you explain when you knew you wanted to be a justice?
Well, so justice is a trickier question. I was interested in being a judge. I think a lot of lawyers are interested in being judges because that's, in law school, they kind of bombard you with lots of opinions written by judges as kind of the basis for legal education. And then I had the good fortune of clerking for a couple of judges who I greatly admired and, seemed like a great thing to do. I spent most of my career before I came on the bench in federal court and thought I might end up on the federal bench. But then as I was finishing up as U.S. Attorney, Leah Sears, who was my predecessor, fairly unexpectedly announced her resignation, and people asked if I was interested in applying. I developed an interest in being a justice on this court about, it ended up being about 7 or 8 months before I became a justice on this court. It was a bit of an unusual path here, but has worked out very well for me individually.
Justice Boggs?
Yeah, I think I agree that, the difference of when you knew you wanted to be a judge versus when you wanted to be a justice. I mean, my interest in law developed really early in my career. My dad was a federal law enforcement agent, and I spent a lot of time talking to him about federal criminal law and going to court with him when he testified in particular matters in which he was involved, which led to my interest in the law and interest in law school. My interest in being a judge was really kind of developed after 4 years of service in the Georgia General Assembly, writing laws and watching those laws as a practitioner when I came home be applied by judges, sometimes I think appropriately and sometimes not. And I also, I think one of the things you can experience as a lawyer is, we ask people, I serve on the JNC and I've served under 2 different governors, and we ask a lot of people, what judge would you emulate? And I think we get a lot of answers are, the attributes that they find most appealing in the judges that they've practiced in front of. Mine was somewhat the opposite. I had practiced in front of some judges that I was confident didn't treat lawyers appropriately and didn't treat lawyers fairly. And so I think you can learn as much from a bad judge as you can a good judge about what aspirational qualities you want to see in a member of the judiciary. But then I guess, lastly, my interest in being on the Supreme Court really was pretty well refined during my service on the Court of Appeals. I had a particularized interest in the jurisdiction of our court. It had just changed. I had been a divorce lawyer. I had been a Superior Court judge. I really wasn't interested in presiding over divorce appeals. But the Appellate Jurisdiction Act shifted about 6 classes of jurisdiction from our court to the Court of Appeals and made the constitutional questions and questions of first impression and other issues that I find intellectually interesting much more appealing to have an interest in the Supreme Court. And like I think most folks that get here, your interest is piqued when there's an opening. And so it was probably 6 months prior, I really felt an interest in it, but I've enjoyed my service.
As a divorce lawyer, I can't understand why you wouldn't want to hear divorce cases.
Most folks can relate, certainly.
Justice Peterson?
So perhaps unlike some of my other colleagues, I was not interested in being a judge in law school or after law school. And it really wasn't until I'd spent maybe a year as Solicitor General litigating constitutional cases, particularly under the state constitution, that I really developed just a real deep interest in the state constitution and how it's interpreted. And this court is the court that does that. You can't take those questions up to the United States Supreme Court. And so I've developed an interest, and then like the others, turned out an opening arose. And that's when the interest became more concrete.
And Justice Warren?
My answer is very similar to Justice Peterson's, in part because we had a similar path, being Solicitor General and engaging with the Georgia Constitution, which generally is not something that you think about when you're in private practice at a big firm, or even really in law school, because most law schools don't teach state constitutional law, even though they should. The one thing I will say is, a lot of times we'll meet folks who will say, I really want to be a judge, and they might be really young in their practice, or they might be more advanced in their practice. They'll say, I really want to be a judge. And on one hand, if that is your singular goal and that's your life's dream, I say go for it. And that's awesome. And I hope it works out. And I hope you are able to do all the things you can to kind of put all the pieces in the right place to increase the chances that happens. On the other hand, I think many of us, we didn't stumble into it, but it was not the path that we had set out for ourselves. And in fact, given how many type A personalities we have on this court, I'm fairly certain that many of us had other very concrete plans that did not end up going the way we thought they would. But we answered the call when the call came, and we're people who care about serving. And I know there are a lot of other people in Georgia who care about serving too. And so to other folks who are not sure what they want to do, or maybe feel a call to service, but they're not sure where that might lead, I would just say, stay open. And the best thing you can do is do the best work you can possibly do and treat people with as much kindness and professionalism as you can all along the way. Those opportunities present themselves sometimes in instances where you would never expect it. And sometimes that's how it leads to a path like this.
And Justice McMillian?
Yeah, so I was one of those people who didn't plan on being a judge, probably because I didn't think I would have the opportunity. I practiced with Sutherland, Asbo, and Brennan for 11 years. And in 2010, I live in Fayette County, and we had a couple of judges resign. And that was really the first time I started thinking about becoming a judge, because I was worried about the community and the bench here. And so I put in for that position and ended up being appointed to the state court in Fayette, and served happily there for a couple of years, and then was appointed to the Georgia Court of Appeals. And it was there when I really developed my interest in becoming an appellate jurist. I mean, I had done appellate work when I was a lawyer, but I really loved the trial work. And as time went on, I think I developed an interest in becoming a Supreme Court justice, because there was an opening, and it was interesting to me to work on the more complicated cases, the constitutional questions and so forth. And so I put in for Justice Benham's spot when he announced that he was going to retire right before COVID hit. And I was appointed and sworn in April of 2020, which meant for the first 18 months I was on the court, it was all by Zoom.
That is trial by fire for sure. And last but not least, Justice Colvin.
Well, like the last three people who mentioned it, I had no idea that I would ever be a judge. I loved litigating. I loved working for the U.S. Attorney's Office. And then one day walked the U.S. Attorney Michael Moore and said he wanted to nominate me to be on the Superior Court in Macon. And even though I was somewhat leery, because I was close to being fully vested, I said, okay, I'll do this. And so then I became a Superior Court judge, thought I would stay there forever. I had hoped to become Chief Judge. And then I had started getting some calls and people pushing me to put my name in for an appellate slot. I resisted for a while, but finally someone called me to the rug and said, if you say you're a public servant, then you should be willing to serve on any level that our state needs you on. And so I put my name in for an appellate position. And so I was fortunate to get Justice McMillian's slot on the Court of Appeals when I put my name in. And then when Chief Justice Melton left, for the first time, I thought, was this trajectory for the purpose of me applying at this point? And so I put my name in, applied for the position, and I've been honored to serve with these colleagues who are teaching me so much as the newest justice on the court.
And let me ask you a question. We've been talking about trajectories, and if you could tell something to your former self, whether it was just out of law school or going into law school, is there something that you would say to your former self to, don't worry about this? Or is there something specific you would say to yourself, knowing that it's going to work out? Y'all have obviously been very successful and it's going to work out, but it's clearly sometimes a rocky road for a lot of us. And I know we have a lot of law students on this call, and we have some younger lawyers on this call who don't know what their path is going to be. Is there something that you would tell your younger self looking back at your career today? Justice McMillian, put you on the spot.
No, I mean, I think that's a great question. I think when I was a younger lawyer, I was so focused on advancing in my career. I worried a lot about it, and I spent a lot of time on it. And later, when I got a little bit more senior, I actually ended up taking a part-time position at my firm because of my two kids. They were younger at the time. Of course, part-time partner at a major law firm is 40 hours a week. But anyway, I would tell my younger self to not worry about that so much, and do what's best for your family and for your life, that things will work out. Obviously, it has worked out for me. So just do the best you can, work hard. But, I would encourage you to put your family first and your life outside of the law, and make sure that you are living a happy, fulfilling life, and not be so focused and overwhelmingly focused on just advancing in my career and working hard.
Justice Peterson, I'm going to put you on the spot. Same question.
I think anything I would have told my former self wouldn't have believed. But I talk to a lot of law students, and it's something I love to do. And you'll see the ones who are really focused on, in 10 or 15 years, I want to be doing X. And that is a perspective that I think can be really constraining, because if you worry about, if I do this thing, then people are gonna, not like that down the road. You need to do the best job you can at what you're doing today. And the people who are most likely to get good opportunities down the road are the people who've not been so focused on what the next thing is that they don't do the best job they can on the thing they're doing now. And that probably is the best piece of advice, other than really learning the rules of evidence, that I could have given my younger self.
Brooke, if I could weigh in on what Justice Peterson, what everyone said.
Of course.
It is interesting that, to me, a lot of the younger students that I speak to are really transparently aspirational. They wear on their sleeve that they want to be a judge, and they're chafing at every moment and applying for every opportunity. And they don't realize that professional development is really an iterative sort of evolutionary process that, to me, goes back to what Justice Peterson just said, which I kind of term as bloom where you're planted. if you do a really good job at whatever it is you're doing, you would be surprised at how well other things somewhat flow from that. But folks that are just, as I call it, transparently aspirational, and they wear on their sleeve this sort of, I've got to be to this point in my life by this particular time. I've told those students that I've rarely known a judge that ever aspired to be a judge. We all kind of got here in a haphazard way, but I would tell you at the base foundation of all of that was some strong academic work in law school and some really good experience as a lawyer in a really broad area, and just doing a good job, being a professional, finding good work-life balance, understanding that you can have aspirations and there's nothing wrong with that, and you should, but that you can also get caught up in the achievement that's necessary to get there, and it can kind of get in the way, I think. So I really appreciate what my colleagues have said, because I've always shared many of those concerns as well.
We are very fortunate to be in a career that offers us flexibility in terms of where we work and when we work and how we work. And obviously with computers and Zoom now, it seems like I could be doing this from the beach, right? And y'all could be sitting wherever and we wouldn't know. And so taking advantage of that, particularly now, I think with everything that everyone has gone through in the past several years, we have to be very cognizant of that. And your points are so well taken, regardless of your age, to stop maybe focusing on the next thing and to be, I love that, bloom where you're planted, and sort of focus on what we have now and to be thankful for that and to concentrate on that so that we're not always looking for the next thing. That's great advice, regardless of where you are in your career. Sort of talking about where everyone has been for the last 2+ years. I know that in some of the superior courts, there is backlog and a little bit in the Court of Appeals. Do y'all have a backlog, or are you sort of operating as normal? Where does that stand for the Supreme Court?
I can say our caseload is actually significantly down on the direct appeal side, meaning especially the murder cases coming from the trial courts, and a little bit across the board. I think the same is true of the Court of Appeals, because the slowdowns in trial courts during the pandemic mean that there aren't as many appeals coming. I describe it as kind of like being on the beach with a tsunami coming. It's kind of nice for us now that we have not quite the press of cases, but you can see that there's a big wave that's going to be coming as the trial courts start gearing up. And I think it's important for lawyers to understand and for the public to understand that, we're already kind of putting COVID in the backseat, the rearview mirror, and moving on. And hopefully that's where we'll feel like as generally in Georgia, in a few months or a year. But this issue in the courts is going to be there for several years, digging our way out of the backlogs while still doing the normal flow of cases coming in. And for the appellate courts, we're going to be on the back end of that. So when we're complaining about our COVID-related workload in 3 or 4 years, well, I won't be complaining. I'll be watching them complain. But you should realize that it's very predictable pattern, because appeals trail trial court judgments.
Well, and we won't have a backlog. We will get rid of whatever cases we have because we're required to. So, we'll have more cases than ordinary, but it's not going to hit for quite a while. But we'll still get them out within the 2-term rule as we're required to do. And so, unlike the trial courts that could put off some things, we're not going to be able to put off deciding those cases. And so, we all see it coming in cases that have been docketed already for the next term, and we start seeing the numbers. And so we kind of know what's coming.
I appreciate that explanation of of seeing the effects for years to come, because as a mostly trial court lawyer, I hadn't yet thought about how that will affect your court going forward a few years from now. And so I appreciate that explanation, because that was not something that I thought about. I'm seeing it now in my trial court cases, but I'm not seeing it yet, obviously, in the Court of Appeals or the Supreme Court cases. So I appreciate you explaining that to us. We have a question about appeals. I've noticed that quite a few appeals, which seemingly involve title to land, are frequently filed in the Supreme Court, but are ultimately transferred to the Court of Appeals. Can someone please explain under what circumstances the court will hear a case involving title versus transferring it to the Court of Appeals?
I'll be glad to give that a shot, Brooke. You heard the presiding justice talk about the transition in appellate jurisdiction. And from the onset or the, I guess, constitution of our court in 1845, started hearing cases in 1846 until 5 years ago, team. Cases involving title to land came directly to the Supreme Court. With the realignment of appellate jurisdiction in Georgia, those cases should properly go to the Court of Appeals. There's still, I think, from habit, a lot of those cases, they file notices in our court, and so we are obligated to transfer them. So it's not a question of our choosing which ones we do and don't hear. It's that the jurisdiction dictates that they don't come here first.
And a good reminder to lawyers to actually read the rules on where appeals go, rather than relying on the last time I did this, 4 or 5 years ago, I did it a certain way, because things change.
It is important to stay up on the rules and read them every time before you're filing something. I notice that every time before I'm filing something, and that's an excellent practice pointer. So thank you for that. And I wanted to ask one more question for y'all. As we're wrapping up here, where I want to be mindful of your time, is there something that those who appear before you, could you give one pointer to folks who appear in front of you? What's your best pointer, I guess, is the way to say it. And I'll start with you, Justice Warren.
I can't resist giving two, so I will. The first is watch the videos of other people's oral arguments. It does not matter if it was on the same topic as yours. It does not matter if you have a criminal case and you watch a civil case. Watch a bunch of them. They're all posted online. It's one of the coolest things about our court. That is if you were preparing for a Friday night football game, you would watch the tapes of the team you were about to play. You'd review the tapes. That's exactly what you do to prepare. You may not figure out what questions we're going to ask about your case, but you're going to understand what the dynamic is between the justices, what the flow of argument is. You're going to see good things that you want to emulate, bad things you don't want to emulate. That is an insurance policy. It should be part of your preparation every single time. And then the second thing is that you must moot your arguments before you come to us. Mooting is just a practice round, but a practice round is not in front of your mirror. That's talking into the mirror. So you can talk into the mirror to practice. That's always good for building self-confidence, but you should practice your argument in front of somebody else, and preferably somebody who's not on the case with complete subject matter expertise, because those people are going to have the same blind spots that you do. You should do it in front of someone who doesn't know all the acronyms you're talking about, doesn't know every single nook and cranny of the case, because they're going to ask similar questions that we ask, just sort of common sense questions about how the arguments work, how things fit together. That is good practice before you come and see us. And we love it when people put all that hard work into advocacy, so that by the time you get in front of us, we do have a great conversation and work together to figure out what the answer is under the law.
Justice Peterson?
I think Justice Warren took mine. Perhaps somebody else?
Justice Bethel?
Justice Warren always takes the best ones, but no. My advice is to be hard on yourself so that you'll be ready when we're hard on you. And what I mean by that is, when you're going to cite a case, don't cite a case that's sort of tangentially on point and expect that it's going to get past 9 people and all of their staff attorneys in a court. It's not, and then it's just going to be awkward and hard, whether it's an oral argument or in addressing a case that's just submitted on the briefs. So make sure that you are being, intellectually honest with yourself about the arguments you're making, because you just won't fool the panel. I mean, you may fool me, but you're not going to get everybody.
Justice Colvin.
One thing I always tell people is continue researching even after you've written your brief. So don't just come and argue what you've already written. Continue looking at other ways to come at the analysis, because the justices will have read everything you've written. So Chief Nahmias, and also Chief Justice Warren, Justice Peterson are going to come with something that you didn't put in your brief. And so if you keep researching, keep looking at things, you're going to find other things to bring out that can help your argument. So don't stop with the brief.
Justice McMillian.
Yeah, I guess I'll be the Justice Warren. I had 2 things. One is for appellants. Most of the cases that we see from the civil side, they come from the Court of Appeals through petitions for cert. So it's really important as the appellant to put out your very best enumerations of error. A lot of times we see people just throwing, tons of enumerations into their brief. And I know as a trial lawyer, every error that the trial court commits, really, you really want that to be fixed, but not all error is reversible error. So it's important to cull those enumerations down to what is the reversible error in this case, so that you can properly argue those particular points, because you're limited in the number of pages. And then that will help you if you end up not getting the result that you want in the Court of Appeals. Then you can take those to the Supreme Court through a petition for cert, and being mindful of our standard of review, which is that issue has gravity, needs to have gravity for us to take it. In order to get to our court, you need to set up your case in such a way with the enumerations of error that you think are the most important, that are winnable, that are reversible errors. So I would encourage you to take a good look at that. Maybe have someone else not involved in the case take a look at it so that you can cull that down.
Those are excellent points. Justice Boggs.
One observation and one recommendation. I think there's a common misunderstanding among many appellate lawyers, and I've heard this through the years of being on both Court of Appeals and our court, that the panel, or on our court, the entire court, is not as familiar with the case as might be the assigned author. And I want to dispel that right out of the gate and just tell you that the number of eyes that are laid on a case before oral argument and the amount of time that goes into the preparation for oral argument, the assigned justice writes a bench brief in every assigned case, every single assigned case that goes to oral argument. Those bench briefs are exhaustive in their length and in their breadth and depth with which they address the pleadings and allegations, enumerations of error of the parties. Everybody on the court will have gone through every bit of that, will have gone through the record, will have looked at all of the briefs that have been filed in the case, which we're seeing more and more amicus briefs and otherwise. So we'll see, all of the briefs of the parties. I think that's demonstrated by the quality of the questions that the lawyers are getting, right? Because they're getting questions. Used to be in the old times, I've been told that, the only person that would be asking question would be the assigned justice on our court. But everybody on our court asks questions, and it demonstrates, I think, the level of preparation and academic rigor that has gone into being prepared. So that's the observation I'd want lawyers to know before they practice before our court. And the advice I would give them would be simply this, and the chief mentions it usually in mass swearing in ceremonies of lawyers. You've kind of got to be able to read the room, and a good lawyer can read a jury. A good lawyer can read the room. You can tell when you've asked a question the jury might be interested in, or one that the jury might not be interested in. We're similar. If we're not asking you a lot of questions, and we've asked the other side a lot of questions, might be a good idea to ask if we have any more and sit down. Chief always tells folks you don't have to use all your time. And I wouldn't say I've seen defeat snatched from the jaws of victory by going too long, but I have seen an issue raised at the very end of oral argument that I really hadn't been thinking about, and all of a sudden it puts things kind of on its head. So, being able to read the room is helpful, and being able to understand kind of and nimble enough to understand that you might not want to be able to recite what you spent all Sunday night preparing for. Maybe you want to start with the questions for the appellant got asked. So, to your point earlier, so that's my observation and my advice.
And I guess a question in response to that is the level of preparation in reviewing petitions for cert lower than the preparation on the case once it's been accepted?
No.
Okay.
I don't think so. I mean, we've got memos in every one of those cases. We're circulating those cases. We're TD in those cases. So we bank those cases. And I will say, every justice is assigned on a wheel. They're all random, but whoever's been assigned a cert petition will present that cert petition at bank. And it's rare that there is if it's a close call on a case, that there's not a pretty rigorous debate about that case. So it is an inclusive sort of collaborative process that I don't think the lawyers can appreciate. And honestly, as a superior court judge, I had no idea that was the level of collaboration that was involved in deciding cases at our court.
And Justice Nahmias, will end with you, but before we do, I think this is probably perhaps my group's last chance. And I just wanted to say thank you for being our Chief Justice for the past couple of years. We just really appreciate you and your leadership. And so what pieces of advice would you give?
Thank you. Two things. The first is pretty straightforward, which is be straight with the court. If you get a question, try to answer the question. The answers aren't always good, but you want to answer the question and not try to deflect it. And you don't have to make concessions. You may say, I can't concede that point, Your Honor, and that's basically a signal that that's just one I can't answer the way the answer might be. The other big one is to understand that appellate courts, and especially the Supreme Court of Georgia, everything we put in an opinion is going to be precedent. So we're going to try to get your case right, but we are equally concerned about figuring out what the effects of whatever we say are going to be on other fact situations in the future, so that we don't say something or write an opinion in a way that we're either going to mess stuff up, often for quite a while before another case can work its way back to us to try to correct it. And when it does get back to us, we have to deal with stare decisis. So we are really concerned about how to write the opinion, how broad, what limiting principles. All of that means you're going to get a lot of hypothetical questions and what about this and what about that questions. For many trial lawyers who have the case and are bringing it and arguing it in front of us, all you want to do is, keep your case alive, or if you lost it, get another chance to try it. That's all you're focused on. And you really don't want to think about or haven't thought about all these ripple effects on similar cases. And so that's how we think, and that's how we need to think. And you've got to try to put your mind the way we're thinking about cases. And, if we ask, let me give you a hypothetical, it's because we're worried about what is the effect of this case on the hypothetical. And the answer should never be, well, that's not this case. It's obviously not this case. That's why we're asking about some other facts, but that's a real mindset issue. Good appellate lawyers naturally think that way. A lot of folks we get don't argue a lot of appeals, and it's very different than when you're in a trial court coming up with what is the best argument. I don't care how I win this case, which argument you want, just let me win. We care a lot about which arguments are going to win a case and how to write the opinions to not screw up the law for the future.
That's a great point, because many of us are uniquely solely focused on our case and wanting to succeed in our case, and we don't think about the ripple effects of how it's going to affect the rest of case law. And so that's an excellent point to think about when we go in. So thank you for bringing that up. And I'm sorry we did go a little bit over, and I want to be respectful of your time. So I appreciate y'all staying a few minutes over to answer these questions. Thank you so much, justices, for answering these questions. We appreciate your time so much, and thank you for everyone for attending. And we appreciate you being here, and thank you so much for answering these questions and appearing on behalf of the Atlanta Bar. I'm Brooke French, and we'll see you next time we have one of these. And thank you so much.